Advocate Rajesh TG and Advocate Johnson Gomez sir and Mr. MP Matthews, Advocate Sunil V. Mohammed sir, now I welcome Advocate Sunil V. Mohammed sir for the
he's the right person, apt personality to be the person to inaugurate this function. So, on behalf of the SCL Kerala chapter and the organizers of this function, I extend a hearty welcome to you, sir. The president of this function, Advocate Johnson Gomez. He is the chairman of the SCL Kerala chapter and a fellow of Chartered Institute of Arbitrators, UK. I would say that he is the mastermind behind all this function. It is his child that now we are going to discuss over. This thing was actually creation of his, especially when we think in the point of view of apartment owners and builders, who are the two major stakeholders in the construction industry. It is his interest of having a detailed discussion to have a clarity on the subject, especially Apartment Ownership Act. Regarding 3 points, he had his focus, which he has expressed to me. According to him, it is the implementation of the Act. Now, the second thing is regarding various amendments that is required to the Act. And third is the regulatory measure, which are the topics which we would today discuss according to me. So, sir, I, for the sake of formality, welcome you to this function, sir. We have Advocate Rajesh T, who will be presenting the topic of the day. He has done a lot of research, and from his face, it appears that he is very confident with the topic, and he would elaborate. I welcome Advocate Rajesh T, who is the chapter member of SCL Kerala, to this function. This is actually, we have a forum discussion, a panel discussion with eminent panelists. First, we have Senior Advocate Amar Rajendran Nair, as a very eminent lawyer. Also, he associates with so many organizations and well known to public as well. So we feel that he is the best person to moderate this panel discussion. Sir, I welcome you to this function. Next, we have Mr. MP Matthews. He is a member of Kerala RERA Authority. And as we all know, we have the RERA Act over here, which was implemented in 2016. And the point of discussion the effectiveness of RERA as well as Apartment Ownership Act. So it's something which has to run together, but for so many reasons. It travels into different paths, and we need to find out a meeting point. So I would Mr. MP Matthews can be a good speaker and a panelist on this function. So I welcome you to this function. Next we have Mr. Cherian John. He's Managing Director of Highway Builders Trishur and Governing Council and Legal Committee member of CREDAI, Kerala. There are many stakeholders involved in this, especially in this topic. One of the major stakeholders, CREDAI, or from the part of builder side. CREDAI can explain so many things and fill up the gaps and lacuna in what the panel or rather the discussion goes on. And I think that Mr. Cherian John would be helpful in this manner. Sir, I welcome you to this function. Now we have Commander Dean John, who is Secretary of Uttama Apartment Owners Association. The most affected part, rather, the majority who finds it difficult to move on in between these two legislations, Apartment Ownership Act as well as RERA. They are the major stakeholders. So without owners or apartment developers, we cannot have a successful discussion. And we thought that Mr. Commander Dean John Matthew, who is an apt person for this function. Sir, I welcome you to this function. It is the process of the personalities of the dais that make any function a success. The phases which I see over here comes from various fields of life, but mostly they are related to construction or rather apartment or condominium, etc. And the audience makes a difference in such discussions and seminars. We have so many personalities, I don't want to mention each and every one, but I welcome you all to this function. Thank you so much.
Thank you so much, Advocate Sunil Mohammed, sir. Next, I request the President of the Society of Construction Law, in that stage on the topic, Advocate John Gomez, sir, to deliver the presidential address.
Good morning, everybody. Most respected Justice P. Gopinath, Judge High Court of Kerala, M.R. Rajendran Nair sir, Matthew sir, Cherian sir, Commander Dean Matthew, my friend Sunil Mohammed, SBG, and all the dignitaries in the dais. Society of Construction Law Law is an organization which was formed in 2019 February, and it was inaugurated by none other than Professor Dr. N.R. Madhavamenon. I remember him, his speech in 2019 when he said that an Amazon delivery boy could not come to court. An Amazon delivery boy happened to be a lawyer. He could not come to court for delivering an Amazon article in this chamber. It was an article written by one of our lawyers of the Kerala High Court, and he was referring to that particular article while inaugurating this organization. He mentioned that because the needs of the society is changing, when the society's needs changes, we cannot sit in the chambers and expect to advise clients as we were doing in the past. We may have to talk in the language of the industry. We need to have to talk in the language of the industry. We need to understand the industry better. And it is how
construction law, I thought I must make this statement. It is about the use of natural resources. I have often felt that we are using up natural resources at such an alarming rate that we will soon run out of natural resources. We are not a natural resource rich country. We have a problem of population, problem of equitable distribution. All people must have access to natural resources. Now, in my previous avatar as a lawyer, I used to appear for many of the industrial units which are now there in this Elur Adayar industrial belt and other places of the state. To take one example of a public sector undertaking, FACT, because of their production process, they generate a lot of gypsum. There is a huge mountains of gypsum lying as waste in the premises of the FACT. The Central Pollution Control Board has asked them to ensure that it is all removed or treated or whatever it is by some date. I'm sure that those dates have gone by. The quantity is so huge that unless we find ways and means of using industrial waste to address our problem of raw material shortage. I've often wondered, there are some other materials, I don't want to go into the specifics, which I thought could be used instead of red earth in the construction of roads, bridges. You see huge amounts of red earth being brought after bringing down mountains, trees, and all these things. So I think this Society of Construction Law must, while they debate on the laws that should, amendments that should come into the laws that govern the construction field, apartment ownership, I think you must also focus on how we can use industrial waste and also focus on recycling of construction waste and all these things in the construction industry. I think this is a very, very important topic, and much faster than we know, we will be facing a dearth of raw materials, which is going to create so much of problem in the society. So tomorrow, we youngsters of today who want to build a house tomorrow will face a situation where they can't find raw materials. So we need to find alternative sources of raw materials, which is, I think, the answer lies in recycling and using industrial waste. Now, using industrial waste, I think, solves two problems. It solves the problem of industrial waste accumulating. And today we have technology. We can possibly ask ChatGPT as to what we should do about gypsum to make it useful in the construction industry, and possibly it will come up with an answer. I can see Hariraj is smiling because he is one of the persons who I feel has been very much behind pushing technology, including into the High Court, and though I have differences of opinion with him on various aspects, I think technology can help us to address this problem of how we will use industrial waste, which is accumulated in our backyard for the purposes of the construction industry. I think that's a huge area. I think I would request the office bearers to please consider this as a very, very important topic of discussion. If you can come up with some solutions, I'm sure we will address two problems, one of accumulated industrial waste, the other of shortage of raw material. And with technology, we can treat industrial waste if required to use it in the construction industry. The other thing, I think, which peculiar, I am sure, now we have seen a couple of months ago, I think the MG Road near the ground junction was relaid or tarred again. I was walking from the hospital road towards MG Road. I've been saying this in court also. The height at which the road has been tarred is about 1.5 feet. We raise the level of roads, the height of the neighboring properties go down. Again, we face a problem of usage of raw material. Why don't we start stripping the roads and reconstructing roads with the material, recycled material after stripping the roads? Why do we lay roads one over the other, using raw materials at such an alarming pace? Now, what happens when the road goes up, the neighboring properties go down? Then the neighboring property owners use up raw materials, buy raw materials, and raise the level of their property. So we are actually using up so much that we have possibly forgotten about the principles of intergenerational equity, and we as a generation, I think we have used up most of the raw materials that are available on the earth, leaving little or none for the future generations. I think this is an important area where the Society of Construction Law will, I'm sure, will do something, come up with some solutions and mechanisms for addressing this problem. With these few words, I inaugurate the Kerala chapter of the Society of Construction Law. I hope that the society will be able to contribute in large measure for the development of law in this very interesting area. And I wish all persons associated with the society great success, and I hope that they will contribute in large measure to the society in general. Thank you. Jai Hind.
Thank you, Justice P. Kognaran, sir. I'm Rita M. Jacob, a student member of SCL Kerala, and I'm delighted to be your co-host for today. Now, I would like to invite Advocate Rajesh T. sir to deliver the presentation of the topic.
Good morning, everybody. ജോസ് സാർ പറഞ്ഞതുപോലെ തന്നെ
സമൂഹം വളരെ വേഗത്തിൽ മാറിക്കൊണ്ടിരിക്കുകയാണ്. സമൂഹത്തിൻ്റെ മാറ്റങ്ങൾക്ക് ഉതകുന്ന രീതിയിൽ നിയമങ്ങൾ കൂടി ഉണ്ടാകേണ്ടത് സമൂഹത്തിൻ്റെ വളർച്ചയ്ക്കും സമൂഹത്തിലെ സമാധാന അന്തരീക്ഷത്തിനും അനിവാര്യമാണ്. ഇതുകൊണ്ട് തന്നെ നമ്മുടെ കേരളത്തിലെ പ്രധാനപ്പെട്ട ഇൻഡസ്ട്രികളിലൊന്നായ ബിൽഡിംഗ് ഇൻഡസ്ട്രിയിൽ ഫ്ലാറ്റ് നിർമ്മാണത്തിൽ സംബന്ധിച്ചും നിയമങ്ങളും വ്യവസ്ഥകളും ഉണ്ടാകേണ്ടത് ബിൽഡേഴ്സിനെയും അതുപോലെ തന്നെ ഈ വീടുകൾ ഫ്ലാറ്റുകൾ വാങ്ങുന്ന ഉപഭോക്താക്കൾക്കും വളരെ അത്യാവശ്യമായിട്ടുള്ള ഒന്നാണ്. ബിൽഡേഴ്സ് നിലനിൽക്കണമെങ്കിൽ പർച്ചേസേഴ്സ് ഉണ്ടാകണം. അതുപോലെ പർച്ചേസേഴ്സിന് എപ്പോഴും ബിൽഡേഴ്സും അനിവാര്യമാണ്. സമൂഹത്തിന് മാറുന്ന അവസ്ഥകളാണ് നമ്മുടെ നഗരങ്ങളുടെ വെർട്ടിക്കൽ ഗ്രോത്തിനെ ഇപ്പോൾ വെർട്ടിക്കൽ ഗ്രോത്ത് ഉണ്ടാകുവാൻ തന്നെ കാരണം. 1979-80 കേരളത്തിലെ ആദ്യത്തെ ഫ്ലാറ്റുകളിലൊന്നായ കടവിൽ കോട്ട് എറണാകുളത്ത് ചിറ്റൂർ റോഡിൽ നിർമ്മിക്കപ്പെട്ടത്. ആ സമയത്ത് കേരളത്തിലെ ഫ്ലാറ്റുകളെ സംബന്ധിച്ച് യാതൊരു നിയമങ്ങളും തന്നെ ഉണ്ടായിരുന്നില്ല. മറിച്ച് അതിനും കുറേ അധികം വർഷങ്ങൾക്ക് ശേഷമാണ് ഈ അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പുകളെ സംബന്ധിച്ച് വ്യവസ്ഥകൾ പോലും ഉണ്ടായത്. ആദ്യകാലങ്ങളിൽ നിർമ്മിച്ച ഫ്ലാറ്റുകളിൽ ട്രാൻസ്ഫർ ഓഫ് പ്രോപ്പർട്ടി ആക്ട് 140 വർഷം പഴക്കമുള്ള വസ്തു കൈമാറ്റ നിയമത്തിന്റെ അടിസ്ഥാനത്തിലാണ് കൈമാറ്റം ചെയ്യപ്പെട്ടു പോന്നിരുന്നത്. 140 വർഷങ്ങൾക്ക് മുമ്പ് വെർട്ടിക്കൽ ഗ്രോത്തിനെ കുറിച്ച് ലോ മേക്കേഴ്സിന് ചിന്തിക്കാൻ കഴിയാതിരുന്നത് നമുക്ക് മനസ്സിലാവും. പക്ഷേ അതിനുശേഷം ഈ നഗരവൽക്കരണം ആരംഭിച്ചതിന് ശേഷം, നഗരങ്ങളുടെ വെർട്ടിക്കൽ ഗ്രോത്ത് ആരംഭിച്ചതിന് ശേഷം ഇതിനെ സംബന്ധിച്ച് വ്യവസ്ഥകൾ ഉണ്ടാക്കാൻ നമുക്ക് കഴിഞ്ഞില്ല എന്നുള്ളത് നമ്മളുടെ തന്നെ കുറ്റമാണ്. ഈ കേരളത്തിൽ നിലവിൽ വന്ന അപ്പാർട്ട്മെന്റ് ഓണേഴ്സ് ആക്ട് അതുപോലും നിലവിൽ വന്നിട്ട് 40 വർഷങ്ങൾ കഴിഞ്ഞിരിക്കുന്നു. പക്ഷേ ഇന്നും ആ നിയമം നടപ്പാക്കാൻ പോലും പൂർണ്ണ തോതിൽ നമ്മുടെ നാട്ടിൽ നിലവിൽ പോലും വന്നിട്ടില്ല. 140 വർഷങ്ങൾക്ക് മുമ്പുണ്ടാക്കിയ ട്രാൻസ്ഫർ ഓഫ് പ്രോപ്പർട്ടി ആക്ടിന്റെ 44-ാം വകുപ്പ് അനുസരിച്ച് നമ്മൾ വസ്തുക്കൾ കൈമാറ്റം ചെയ്യപ്പെടുമ്പോൾ ഉണ്ടാകുന്ന പ്രശ്നം, ആ 44-ാമത്തെ വകുപ്പ് ആ കാലത്ത് നിർമ്മിക്കപ്പെട്ട കാലത്ത് ഉണ്ടായിരുന്ന അന്ന് നിയമനിർമ്മാതാക്കൾക്ക് മനസ്സിലായിരുന്ന കാര്യം ജോയിന്റ് പ്രോപ്പർട്ടികളെ സംബന്ധിച്ചാണ്. കാരണം ഏതെങ്കിലും ഒരു വ്യക്തി മരിച്ചു കഴിഞ്ഞാലോ അല്ലെങ്കിൽ ഒരു 2-3 വ്യക്തികൾ ഒരുമിച്ച് ചേർന്ന് മേടിച്ചിരിക്കുന്ന വസ്തുക്കൾ കൈമാറ്റം ചെയ്യുന്നതിനെ കുറിച്ചും ആ വസ്തുക്കളിൽ ഏതെങ്കിലും ഒരാൾക്ക് മാത്രമായിട്ട് അയാൾക്കുള്ള അവകാശം കൈമാറ്റം ചെയ്യപ്പെടാൻ പറ്റുമോ എന്നുള്ളതൊക്കെയായിരുന്നു അതിനകത്തെ പ്രതിവാദ വിഷയം. എന്നാൽ ആ കാലത്ത് ഉണ്ടാക്കിയിരിക്കുന്ന നിയമത്തിനനുസരിച്ച് ഒരു ജോയിന്റ് പ്രോപ്പർട്ടി ഉണ്ടെങ്കിൽ ആ ഉള്ള പ്രോപ്പർട്ടിയുടെ ഓരോ സ്ക്വയർ ഇഞ്ചിനും അതിനകത്തുള്ള ബാക്കി എല്ലാ ഉടമസ്ഥർക്കും തുല്യ അവകാശമാണല്ലോ. ആ നിയമപ്രകാരം കൈമാറ്റം ചെയ്യപ്പെട്ടിരിക്കുന്ന നമ്മുടെ ഫ്ലാറ്റുകളുടെ അവസ്ഥയിൽ അതുകൊണ്ട് തന്നെയാണ് ജോൺസൺ സാർ നേരത്തെ സൂചിപ്പിച്ചത്, നമ്മൾ പ്രൈവറ്റ് പ്രോപ്പർട്ടി ആണെന്ന് കരുതുന്ന നമ്മുടെ ഫ്ലാറ്റിന്റെ സ്വകാര്യ സ്പേസ്, നമ്മുടെ പ്രൈവറ്റ് ഏരിയ, ആ ഏരിയയിൽ പോലും തൊട്ടടുത്ത ഫ്ലാറ്റുകാരനും അല്ലെങ്കിൽ നമ്മുടെ ഫ്ലാറ്റ് സമുച്ചയത്തിലുള്ള മറ്റുള്ളവർക്കും ഒരവകാശം കൂടി ഇതിനകത്ത് ശ്രദ്ധിച്ചിട്ടുണ്ട്. അത് മാത്രമല്ല, ആ പ്രോപ്പർട്ടി നമുക്ക് പാർട്ടീഷൻ ചെയ്ത് കിട്ടാൻ വേണ്ടി കോടതികളെ സമീപിക്കാവുന്നതാണ്. അങ്ങനെ സമീപിക്കപ്പെട്ടു കഴിഞ്ഞാൽ അതുണ്ടാക്കുന്ന നിയമപ്രശ്നങ്ങൾ അത് വളരെയധികം ഗുരുതരവുമായിരിക്കും. 100-150 ഫ്ലാറ്റുകളുള്ള ഒരു ഫ്ലാറ്റ് സമുച്ചയത്തിലെ ഏതെങ്കിലും ഒരു ഉടമസ്ഥൻ അതനുസരിച്ച് പാർട്ടീഷൻ നടത്തുവാൻ വേണ്ടി ചെന്ന് കഴിഞ്ഞാൽ ചിലപ്പോൾ പാർട്ടീഷൻ ചെയ്യുമ്പോൾ അയാൾക്ക് ഉള്ള പ്രൈവറ്റ് പ്രോപ്പർട്ടിയും അയാൾക്ക് മറ്റ് കോമൺ ഏരിയയിലുള്ള അൺഡിവൈഡഡ് റൈറ്റ് കൂടി പാർട്ടീഷൻ ചെയ്ത് കൊടുക്കേണ്ടി വന്നു കഴിഞ്ഞാൽ അതുണ്ടാക്കുന്ന ബുദ്ധിമുട്ടുകൾ ഉടമസ്ഥർക്കും അതുപോലെ തന്നെ നിർമ്മാതാക്കളും മനസ്സിലാക്കിയിരിക്കുന്നത് ആവശ്യമാണ്. നമ്മൾ ഇതുകൊണ്ട് തന്നെയാണ് കേരള അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട് 1983 നിലവിൽ വന്നത്. 2023 ആകുമ്പോൾ 40 വർഷം പൂർത്തിയാകുന്നു. 1983 നിലവിൽ വന്ന കേരള അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട് അത് തീർച്ചയായും നമുക്ക് ഈ രംഗത്ത് പരിചയമില്ലാത്തതുകൊണ്ട് മഹാരാഷ്ട്രയുടെ അനുഭവങ്ങൾ അതിന്റെ സെക്ഷൻ 2 അനുസരിച്ചാണ് ഈ പ്രോപ്പർട്ടികളെ സംബന്ധിച്ച് ഈ പ്രോപ്പർട്ടികൾ ഏതൊക്കെ ഏരിയകൾ കോമൺ ഏരിയകളാണെന്നും ഏതൊക്കെ ഏരിയകൾ സ്വകാര്യ ഏരിയകളാണെന്നും നിർവചിക്കുന്നത്. കോമൺ ഏരിയ ആയി വരുന്ന വസ്തുക്കളിൽ ഉള്ള അൺഡിവൈഡഡ് ഇൻട്രസ്റ്റ് അത് അവർക്ക് തുടർന്നും അനുഭവിക്കാവുന്നതും, അതേസമയം പ്രൈവറ്റ് പ്രോപ്പർട്ടി ആയിട്ട് നിൽക്കുന്ന നമ്മൾ പറയുന്ന ഫ്ലാറ്റിനുള്ള ഭാഗം, ആ ഭാഗം നമുക്ക് നമ്മുടെ സ്വകാര്യ വസ്തുവായിട്ട് അനുവദിച്ചു തന്നിരിക്കുന്നതും അത് പിന്തുടർച്ചാവകാശ പ്രകാരമോ അല്ലെങ്കിൽ മറ്റ് ട്രാൻസ്ഫർ പ്രോപ്പർട്ടി ആക്ട് അനുസരിച്ച് വിൽപ്പനയ്ക്കോ അല്ലെങ്കിൽ എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ ലീസോ ഒരുക്കി അങ്ങനെയൊക്കെ കൊടുക്കാൻ അനുവദിക്കുന്നത് കേരള അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട്. അതിങ്ങോട്ട് തിരിച്ചു വെച്ചാൽ മതി. അതിങ്ങോട്ടും തിരിച്ചു വെച്ച് കഴിഞ്ഞാൽ പക്ഷേ ഇങ്ങനെ കേരള അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട് അനുസരിച്ച് ഒരു വസ്തു രജിസ്റ്റർ ചെയ്യുന്നതിന് വേണ്ടി, ഒരു ഫ്ലാറ്റിന്റെ ബിൽഡിംഗ് ഓണർഷിപ്പ് രജിസ്റ്റർ ചെയ്യുന്നതിന് വേണ്ടി, ഒന്ന് ഇതിന്റെ പ്രൊമോട്ടർ, ബിൽഡർ ഈ പ്രോപ്പർട്ടിയെ സംബന്ധിച്ച് ഒരു ഡിക്ലറേഷൻ, ജോൺസൺ സാർ നേരത്തെ തന്നെ സൂചിപ്പിച്ചാണ്, ഒരു ഡിക്ലറേഷൻ സമർപ്പിക്കണം. അല്ലാത്ത പക്ഷം ഇത് എഴുതി വാങ്ങിയിരിക്കുന്ന ഫ്ലാറ്റിലെ മുഴുവൻ ആളുകളും കൂടി ചേർന്ന് ഒരു ഡിക്ലറേഷൻ സമർപ്പിക്കേണ്ടതുണ്ട്, സബ് രജിസ്ട്രാറിന് മുമ്പിൽ സമർപ്പിക്കേണ്ടതുണ്ട്. അങ്ങനെ ആകുമ്പോൾ മാത്രമേ ഈ വസ്തുവിന്റെ കുറെ ഭാഗങ്ങൾ കോമൺ ഏരിയയെയും മറിച്ചുള്ള ഭാഗങ്ങൾ നമ്മുടെ സ്വകാര്യ വസ്തുവായിട്ട് നമുക്ക് നിയമപ്രകാരം അനുവദിക്കപ്പെട്ട് കിട്ടുന്നു. പക്ഷേ ഈ നിയമം 40 വർഷമായിട്ടും നിലവിൽ വന്നിട്ടില്ലാത്തത് കൊണ്ട് തന്നെ നിലവിൽ നമ്മൾ വിൽപ്പനകൾ നടത്തിയിരിക്കുന്ന ഫ്ലാറ്റുകളുടെ ഓണർഷിപ്പിനെ സംബന്ധിച്ചും ആ ഫ്ലാറ്റിന്റെ കോമൺ ഏരിയകളെ സംബന്ധിച്ചും തർക്കങ്ങൾ ഉടലെടുക്കാൻ ഇങ്ങനെ ഇത് എന്തുകൊണ്ട് നടപ്പാക്കാൻ കഴിഞ്ഞിട്ടില്ല എന്നുള്ളത് അതിന്റെ ചില പോരായ്മകളുണ്ടാണ്. അതിന്റെ പോരായ്മകളിൽ ഒന്ന്, ഈ പറയുന്ന നിയമപ്രകാരം ഒരു കോമ്പീറ്റന്റ് അതോറിറ്റി ആണെന്നുള്ളത്. അതുപോലെ കോമ്പീറ്റന്റ് കുറിച്ച് പറയുന്നുണ്ടെങ്കിലും കോമ്പീറ്റന്റ് അതോറിറ്റിയുടെ പവേഴ്സിനെ കുറിച്ച് ഇതിനകത്ത് വ്യക്തത ഇല്ലാത്തതാണ്. രണ്ടാമത്തെ കാര്യം, പ്രൊമോട്ടർ പലപ്പോഴും ഈ പറയുന്ന ആക്ട് പ്രകാരം ഒരു ഡിക്ലറേഷൻ കൊടുക്കാൻ തയ്യാറാകുന്നില്ല. മൂന്നാമത്, നാച്ചുറലി എല്ലാ ബിൽഡിംഗ് ഓണേഴ്സോടും കൂടി ഒരു ഡിക്ലറേഷൻ കൊടുക്കുക എന്നത് തികച്ചും അപ്രായോഗികമായതുകൊണ്ടാണ്. അടുത്ത സ്ലൈഡ്. അടുത്തേക്ക്. ഇതുകൊണ്ടുണ്ടാകുന്ന ഒരു പ്രധാന പ്രശ്നം, നമ്മുടെ കോമൺ ഏരിയകൾ ഏതെങ്കിലും തരത്തിൽ മറ്റൊരു ആവശ്യത്തിന് വേണ്ടി മാറ്റി ഉപയോഗിക്കാൻ വേണ്ടി ഫ്ലാറ്റ് ഓണേഴ്സിനും അല്ലെങ്കിൽ ബിൽഡേഴ്സിനും സാധ്യമാകുന്നില്ല എന്നുള്ളതാണ്. എന്നാൽ പലപ്പോഴും ഈ ഒരു കാര്യത്തിൽ ബിൽഡേഴ്സിന് ഒരു അപ്പർ ഹാൻഡ്, കേരള അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട് പ്രകാരം ഈ വസ്തുക്കൾ രജിസ്റ്റർ ചെയ്യാത്തതുകൊണ്ട് ബിൽഡേഴ്സ് അത് സെക്കൻഡ് ഫേസിനും തേർഡ് ഫേസിനും ഉള്ള സമയത്ത് അവർ ഈ കോമൺ ഏരിയകൾ പലപ്പോഴും മറ്റു രീതിയിൽ ഉപയോഗിക്കുന്നതായ സംഭവങ്ങളുമുണ്ട്. ഇങ്ങനെ സംഭവിച്ച ഒരു കേസിൽ 2021 സുപ്രീം കോടതി ബിൽഡേഴ്സിന്റെ ഈ പറയുന്ന ബിൽഡിംഗ് ഓണേഴ്സിന്റെ കൺസെന്റ് കിട്ടാതെ ഈ കോമൺ ഏരിയ ഇനം മാറ്റിയതിനെ സംബന്ധിച്ച് വിധി പറയുകയും അതിനോട് ചേർന്ന് പിന്നീട് പണിത കെട്ടിടങ്ങൾ, അതിന്റെ അടിസ്ഥാനത്തിൽ പിന്നീട് പണിത കെട്ടിടങ്ങൾ പൊളിച്ചു മാറ്റുവാൻ തന്നെ നിർദ്ദേശിക്കുന്ന ഒരു സാഹചര്യം ഉണ്ടായിട്ടുണ്ട്. ഈ അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് അനുസരിച്ച് ഈ അപ്പാർട്ട്മെന്റ് ഓണേഴ്സ് കിട്ടുന്ന ചില ബെനിഫിറ്റുകൾ, ഒന്ന്, അപ്പാർട്ട്മെന്റിന്റെ മേൽ എക്സ്ക്ലൂസീവായ ഓണർഷിപ്പും പൊസഷനും കിട്ടുന്നു. അതുകൂടാതെ അപ്പാർട്ട്മെന്റിനോടൊപ്പം നമുക്ക് കിട്ടിയിരിക്കുന്ന അൺഡിവൈഡഡ് ആയ ഇൻട്രസ്റ്റ്, അത് നമുക്ക് അൺഡിവൈഡഡ് ആയി തന്നെ എൻജോയ് ചെയ്യാൻ പറ്റുന്നു. മൂന്നാമത്, നമ്മുടെ ഫോം ചെയ്തിരിക്കുന്ന അസോസിയേഷന് നമ്മൾ ഈ കോമൺ ഏരിയ മാനേജ് ചെയ്യാൻ വേണ്ടിയുള്ള അധികാരം സ്ഥിതിക്കുന്നു. ഇതിനു വേണ്ടി ബിൽഡറിന്റെ ഒരു ഡിക്ലറേഷൻ, ഫ്ലോർ പ്ലാൻ സഹിതം ഉള്ള ഒരു ഡിക്ലറേഷൻ കൊടുക്കേണ്ടതായിട്ടുണ്ട്. അതുപോലെ തന്നെ ഈ അപ്പാർട്ട്മെന്റ് ഓണേഴ്സിന്റെ അസോസിയേഷന്റെ ബൈലോ ഇതിനോടൊപ്പം ഹാജരാക്കേണ്ടതുണ്ട്. അങ്ങനെ ഹാജരാക്കുന്ന മുറയ്ക്ക് കോമ്പീറ്റന്റ് അതോറിറ്റി അതിന് ഒരു നമ്പർ ഇട്ട് നമ്മുടെ അസോസിയേഷന് അംഗീകാരം നൽകുന്നതായിരിക്കും. അടുത്തത് ഇത് പ്രകാരമല്ല, റെറായുടെ നിയമപ്രകാരം മുഴുവൻ അപ്പാർട്ട്മെന്റ് ഓണേഴ്സിന്റെയും മുഴുവൻ അപ്പാർട്ട്മെന്റുകൾ വിറ്റ് തീരുന്നവരെ ഈ അസോസിയേഷൻ നിർമ്മിക്കാൻ വേണ്ടി, അസോസിയേഷൻ രൂപീകരിക്കാൻ വേണ്ടി കാത്തിരിക്കേണ്ടതില്ല. റെറ നിയമപ്രകാരം 50% ബുക്കിംഗ് കംപ്ലീറ്റ് ആകുമ്പോൾ തന്നെ അവരെ ഉൾപ്പെടുത്തി അസോസിയേഷനും ബൈലോയും രൂപീകരിക്കേണ്ടതാണ്. അങ്ങനെ രൂപീകരിക്കുന്ന അസോസിയേഷന് ഒരു കോപ്പറേറ്റീവ് സൊസൈറ്റി ആകാം, അല്ലെങ്കിൽ എന്ന് പറഞ്ഞാൽ ഫെഡറേഷൻ ആകാം, അല്ലെങ്കിൽ നിയമപ്രകാരം അനുവദിച്ചിട്ടുള്ള മറ്റേതെങ്കിലും രൂപത്തിലുള്ള ഒരു സംഘടനാ രൂപവും ആകാം. അങ്ങനെ രൂപീകരിക്കുന്ന അസോസിയേഷന്റെ കയ്യിലേക്ക് ഈ കോമൺ ഏരിയ പ്രൊമോട്ടർ ട്രാൻസ്ഫർ ചെയ്ത് കൊടുക്കേണ്ടതാണ്. കേരള അപ്പാർട്ട്മെന്റ് ഓണേഴ്സ് അസോസിയേഷൻ അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട് അനുസരിച്ച് ഇങ്ങനെ ഒരു സൊസൈറ്റി രൂപീകരിക്കുന്നതിന് വേണ്ടി ആദ്യം ബിൽഡറോ അല്ലെങ്കിൽ ഈ ഓണേഴ്സിന്റെ അസോസിയേഷനോ ഒരു ഡിക്ലറേഷൻ കൊടുക്കേണ്ടതുണ്ട്. ആ അസോസിയേഷന് ഡിക്ലറേഷൻ കൊടുക്കണമെങ്കിൽ അസോസിയേഷൻ രൂപീകരിക്കണം. അസോസിയേഷൻ രൂപീകരിച്ചിട്ട് അസോസിയേഷന്റെ സെക്രട്ടറി വേണം ഈ ഡിക്ലറേഷൻ കൊടുക്കാൻ. ഇതിവിടെ ഒരു ബോർഡിലേക്ക് ഉണ്ടാക്കുന്നു. അസോസിയേഷൻ രൂപീകരിച്ചെങ്കിൽ മാത്രമേ അതിനൊരു സെക്രട്ടറി ഉണ്ടാവുള്ളൂ. എന്നാൽ അസോസിയേഷന്റെ സെക്രട്ടറിക്ക് മാത്രമേ ഈ നമ്മുടെ ഈ പറയുന്ന ഡോക്യുമെന്റ്സ് എല്ലാം ഹാജരാക്കാനും അനുവാദമുള്ളൂ. ആ ഡോക്യുമെന്റ്സ് ഹാജരാക്കിയെങ്കിൽ മാത്രമേ അസോസിയേഷൻ രൂപീകരിക്കപ്പെടുകയുള്ളൂ. അപ്പോൾ മാറണോ മാങ്ങിയാണോ മൂത്തെന്ന് എപ്പോഴും പ്രശ്നം ഉണ്ടാകുന്ന പോലെ അസോസിയേഷൻ രൂപീകരിച്ചെങ്കിൽ മാത്രമേ അസോസിയേഷന് ഈ പ്രോപ്പർട്ടി കൊണ്ട് കൊടുക്കാൻ പ്രോപ്പർട്ടി രജിസ്റ്റർ ചെയ്യാൻ പറ്റൂ. പക്ഷേ ഈ പ്രോപ്പർട്ടി രജിസ്റ്റർ ചെയ്യുന്നപ്പോൾ മാത്രമേ അസോസിയേഷൻ രൂപീകരിക്കപ്പെടുന്നതുള്ളൂ. അങ്ങനെ ഒരു പ്രശ്നം ഉടലെടുക്കുന്നുണ്ട്. നമ്മുടെ ഈ രൂപീകരിക്കുന്ന കോണ്ടോമിനിയം മാനേജ്മെന്റ് അസോസിയേഷൻ കമ്പനിയുടെ രൂപത്തിലാകാം, അല്ലെങ്കിൽ കോപ്പറേറ്റീവ് സൊസൈറ്റിയുടെ രൂപത്തിലാകാം, അല്ലെങ്കിൽ കേരള അപ്പാർട്ട്മെന്റ് ഓണേഴ്സ് അസോസിയേഷന്റെ അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ട് അനുസരിച്ചുള്ള ഒരു അസോസിയേഷനും ആകാം. നമ്മുടെ മുമ്പിൽ ഈ നിലവിലുള്ള നിയമത്തിലെ പോരായ്മകൾ പരിഹരിക്കുന്നതിന് വേണ്ടിയുള്ള സജഷനുകളിൽ ഒന്ന് നമ്മുടെ നിലവിലുള്ള കേരള അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് ആക്ടിന്റെ വ്യവസ്ഥകളിൽ അനുയോജ്യമായ രീതിയിൽ ഭേദഗതികൾ വരുത്തുക എന്നുള്ളതാണ്. രണ്ടാമത്, കോമ്പീറ്റന്റ് അതോറിറ്റിയുടെ അധികാരങ്ങളെ സംബന്ധിച്ച് വ്യക്തതയും കൃത്യതയും വരുത്തേണ്ടത് ആവശ്യമാണ്. അതുപോലെ തന്നെ കോണ്ടോമിനിയം മാനേജ്മെന്റിനെ സംബന്ധിച്ച് റെറ അതോറിറ്റിയുടെ ഭാഗത്തു നിന്നും ചില റെഗുലേഷൻസ് നിലവിൽ ആവശ്യമായിട്ടുണ്ട്. ഇത്രയും കാര്യങ്ങൾക്ക് നമുക്ക് അനുയോജ്യമായ രീതിയിലുള്ള നിയമങ്ങളും അനുയോജ്യമായ രീതിയിലുള്ള നിയമത്തിലുള്ള മാറ്റങ്ങളും രൂപീകരിക്കുന്നതിന് ഇന്നത്തെ ചർച്ച സഹായിക്കട്ടെ എന്ന് ഞാൻ ആശംസിക്കുന്നു. എല്ലാവർക്കും നന്ദി.
Thank you, Advocate Rajesh sir. And now we'll move on to the panel discussion. I would like to introduce the members for the same. The moderator for the panel discussion will be our respected senior advocate, Rajendra Nair sir. And we have four speakers. To begin with, Mr. M. Matthew, Mr. M. Matthew sir, member of Kerala Real Estate Regulatory Authority, and M. Sharim John sir, Managing Director, Highland Builders Thrissur, and Governing Council and Legal Committee member of CREDAI Kerala, and Commander Dean Matthew sir, Secretary of Rhythm Ownership Association, and Johnson Gomez sir, President of SCL Kerala. Thank you.
Now that the subject is presented by Mr. Rajesh and some details are already given by the President, Mr. Johnson Gomez, moderator's job becomes easy. Today we are discussing one act, namely Kerala Apartment Ownership Act 1983. We are discussing the problems of implementation after 4 decades of legislation. Often that happens. Advocates here will know about the Advocates Act, which is of 1961. Even today, certain provisions are not notified, so that the legislative enacts, executive
inaction will lead to problems. This enactment has got a peculiar provision that this requires a registration by the builder or promoter before transferring the property to purchasers. He should have done that, but law does not insist on doing that. It leaves registration even at a subsequent stage. Only thing is, majority of the all the purchasers should express no objection. Practically an impossible provision. I think we have developed such an argument, matter is pending before the court. Impossibility cannot be enforced by law. Any law enforcing, attempting to enforce impossibility is unjust, and unjust law is not law. Supreme Court has pronounced in various statements, not regarding the Kerala Appointment Nomination Act. Therefore, a way out has to be found out by judicial intervention. I think already Johnson has made an attempt, and I have also applied my mind to that. Now, let the law develop as suggested by the President. As the society develops, law also should keep the way open. Now, this discussion today will be for understanding the provisions clearly and recognizing the methods of implementation. If there is inaction by the executive, it is for the builders or the purchasers for that affected party. It is for the affected party, for the apartment owners, for purchasers affected. They should do. They should seek judicial redress. When the problem confronting us is regarding the legislative inaccuracy or executive inaction, it is ultimately for the court, to the court, high court, and no effective approach is made. Perhaps Society for Construction Law will be able to take up this in public interest, for the interest of purchase. Interest of purchasers who have paid money for purchasing has to be protected. Any government would agree, any authority would agree also. Because ultimately, it is for the purchasers. Once the promoter purchases land, develops, makes construction, promoters may be in the maybe beneficiaries of the purchases. Nothing more than that. But we have got a very peculiar situation on account of the wording used in Section 2. That is the problem with this act. Because the other portions are not implemented, we do not know what are the situations which will confront us and which will reverse. As a moderator, I don't speak more at this stage. We have got eminent panelists who are experts and who are eminent people who know the law, who are trying to know the law. Therefore, let us hear the panelists on the points of view now that the subject is presented. I request Kerala member, Sri MP Matthews, to put his views across. Yeah. Okay. Yeah.
I think sound is well. Respected Senior Advocate M.R. Rajendra, dignitaries on the dais, and advocates and builders and the stakeholders who are present here. I would like to present this in two parts. One is post-RERA, and the other is before RERA came into being. Before RERA came into being, Real Estate Regulatory Authority, I am saying RERA, before RERA came into being, all these associations were registered mostly under the Charitable Societies, Travancore Cochin Charitable Societies Act. And these associations are functioning. But there was efforts to register the association under the Apartment Ownership Act also. And there were litigations as early as, I understand, from 2014. There was an order of the Honorable High Court to make sure that registers are available. But nothing happened. There was contempt of cases filed. But ultimately, as I understand, the first association was formed by Advocate Johnson for Trithwam under this Act. So now, after the law has come into being, I think there are certain restrictions. There are certain amendments that have to go away for implementation of this Act. One of them is very important is Clause 20 of the prescribed format of the agreement under Real Estate Regulatory Authority clearly states, that is the prescribed under Rule 10 of the Kerala Real Estate Regulatory Rules framed in 2018 notified. Under that, the prescribed format is there. In the prescribed format, as per Clause 20 of this format, it is clearly mentioned the promoter has assured the allottees that the project in its entirety is in accordance with the provisions of the Kerala Apartment Owners Act 1983. So this is something which the builders have not seriously understood. We had some sessions with the builders in Trivandrum and also in Kochi, where I had explained this very important part, that so far they could have escaped from the declaration under Section 2 of the Act, which is under challenge Kerala Apartment Ownership Act. But now for the new projects, in the agreement, it is clearly specified that it is subject to this Apartment Ownership Act. So, for all those projects registered with us that are registrable, that has not obtained occupancy certificate before 1/5/2017, come under Real Estate Regulatory Authority, and all the agreements has to be under the prescribed format. That means if there is an agreement where it clearly states that the apartment is this particular law is applying, Apartment Ownership Act. But then there are certain serious issues which we have already brought to, because Section 32, under Section 32, we are supposed to inform the government, advise the government, recommend these issues that are affecting the implementation of this law. And we have already brought this to the notice of the government, that though it is mentioned that Kerala Apartment Owners Act 1983 is applicable, the definitions under the Act do not satisfy the requirements of RERA, because federal law will ultimately prevail, and already there is an order of the Rajasthan High Court saying that undivided share cannot be registered in the name of the apartment owner. But under our Apartment Ownership Act, undivided share has to be registered in the name of the association only. And there are certain serious issues affecting, concerning that, who is to pay the registration charges. The entire registration charges, everything is paid by the allottee, but when it is transferred to the association, who will bear? So I think 10,000 rupees was fixed by the Rajasthan RERA for registration, and nothing else is to be paid. So those amendments also have to come before us. But the most serious thing is the definition of apartment says, or the apartment owner says, that only a person who has ownership over the undivided rights can be a member of this apartment under the Apartment Ownership Act. So See, litigations are going to come up in future over this. So what we have suggested is, if I already forwarded to Johnson before submitting it to the government, then we have seriously pursued it with the government. So all those who are registered under the Charitable Societies Act before the they will have certain problems as far as implementation of Apartment Ownership Act. Even otherwise, I don't think any amendments can be brought in before the actual law is passed. Whether it can be also be considered for projects that were completed before 5/2017. The most important thing we have suggested is the definition should be in conformity with the definition of apartment is clearly mentioned under our Act. The definition of an association of allottees, it is not an owners association, it is an allottees association. After 50% of the apartments are booked, the association has to be formed. So there is no provision under the Apartment Ownership Act to register an association under the Apartment Ownership Act after 50% is booked. So we have brought in with I'll just read out some of the important definitions, the important changes that are required. That is, one is, and also another thing is the common area includes the entire land. The entire common area, staircase, everything goes to the association. And what the apartment owner gets is only the carpet area. So the carpet area has to be transferred under Section 17 to the allotee, and everything else goes to the association. So if I read out the Section 17 transfer of title, the promoter shall execute a registered conveyance in favor of the allotee, along with the undivided proportional title of areas to the association of the allottees or the competent authority, as the case may be, and hand over the physical possession of the plot, apart or building as the case may be, to the allottees, and the common areas to the association of the allottees or to the competent authority. And common area has been clearly defined under this Act, which is going to create problems for the allotee, the builder, and future maintenance of this property. So, though RERA has made it compulsory for the promoter to come under this Act, I don't think it is going to happen in the near future if this government is very seriously now considering amendments. So if I can read out the common area definition under this Act, the entire land for the real estate project or projects developed in phases and registration under this Act is sought for a phase, the entire land for the phase. The staircases, lifts, staircase and lift lobbies, everything except the carpet area of the apartment, because we are asking on our website if any allottee who wishes to buy an apartment goes and finds out, explore, we have asked the builder to mention the carpet area, then there's a balcony area, the share of common area, only these details will be available. This is what ultimately the allottee is going to get. But only the enjoyment of the undivided share is possible. Ownership of the undivided share will not be passed on, and therefore the present allottees who of projects that are registered with the RERA cannot be coming under the Apartment Ownership Act by virtue of this. So we have asked the government to add the definitions to be in line with RERA, and we have given a complete proposal. All the amendments that are required, the whole thing has been given. We have already mailed it to builders. Almost all the stakeholders are aware of this because we started this process almost 6 months back. We had discussions. With the municipal authorities. Every district we had conducted meetings of all the panchayat secretaries, municipal secretaries, corporations. Everywhere we have convened meetings, each district. And this process was completed. We could understand there are serious problems related to the implementation of RERA, especially it's not only apartment that is coming under the definition, even plots, because common area is involved even in the plot development. And what has happened
happening now is plotted development is happening without registration with the authority. Though it is to be registered, it is continuing even in our district of Ernakulam, where plotted development is happening in a large scale without registration. And this government has also brought in a notification saying that occupancy certificate will not be issued to projects that are not registered with KERERA. 1st of January 2022, no project will get the occupancy certificate if implemented by the local bodies. How far the local bodies are aware of this government notification, even though they are aware, they will find means to get out of it. So the project has to be registered with KERERA if it requires an occupancy certificate. Or there should be a certificate from us saying that this particular real estate project does not come under the real estate regulatory authority. So most of the people who are buying plots that are not registered with RERA will come back to us subsequently saying that, this I am not getting the occupancy certificate. So though RERA is implemented, there are people who buy plots, apartments that are not registered with RERA and getting into serious trouble and coming to us for redressal. And every agreement has to be registered before 10% of the payment is made. So I don't want to give a detailed proposal, but I will just go to the most important suggestions we have brought in. Application of the Act is one area. What we have mentioned is this Act applies to all apartments registrable under the Real Estate Regulatory Authority under Section 3 of the Real Estate Regulation and Development Act 2016 and to property where the sole owner, and we have specifically defined the sole owner. The sole owner is the landowner in whose name the permit is received. What happens in most of the cases, the builder is not the landowner. So the permit is in the name of the landowner, and it is the duty of the landowner to submit, applying for registration, the permit is in the name of the landowner. So we have mentioned with the sole owner in whose name the development, construction permit is obtained under the Kerala Municipality Panchayat Building Rules, or all the apartment owners who have obtained title to the apartment. There are certain cases where now most of the apartments are transferred in the name of the apartments, like the case which Johnson was fighting. Most of the apartments are already transferred. So now what they can do is only all the owners have to go and submit themselves to the Act. But in that agreement also, they have specifically mentioned that all the allottees shall be under the Apartment Ownership Act. So I don't know whether, even though that has been under challenge before the Honorable High Court, because the agreement, all the owners have agreed to come under the Apartment Ownership Act. The association that is presently formed under the Apartment Ownership Act is under challenge, if I am correct, isn't it? That is what has happened. So whether it will withstand, because they have already given a commitment under the agreement, and it is a registered agreement also. So it is, as far as that case is concerned, we don't know how successful it will be. Then association of allottees means an association formed as required under Section 11(4)(e) of the Real Estate Regulation and Development Act. That is something which we want the government to include. Then the common areas, almost the definition of common areas and in the Apartment Ownership Act and RERA Act is similar, except the transfer of the property undivided share is concerned. The definition is almost similar in the Apartment Ownership Act, and almost everything is coming under the common area. So we want an association to be formed after 50% is sold, and that association should be formed, means, we need an amendment to the Apartment Ownership Act, which is very crucial. Then we have also mentioned the the land, buildings, improvements. I think that is also same what is now there in the present act. We are not. Then ownership of apartments plot. That is something which is very crucial. Each apartment plot owner shall be entitled to the exclusive ownership and possession of his apartment or plot. The owner of the property in whose name the development construction permit is obtained under the Kerala Municipality Panchayat rules, and each apartment owner shall execute a declaration. There are two declarations under the Apartment Ownership Act. One is to be made by the, as far as we are concerned, we are saying that it should be made by the landowner or the promoter, whoever owns the land and who has obtained the permit. So they should immediately after obtaining the permit and also after registering with us, though we have been advising this builders, I don't know whether they have started registering, because recently we had a discussion with the IG registration, and we understand that even the agreements are not being registered under section 13(2). So these are going to come up in the near future. So once the apartment is registered with us, it is a responsibility of the plot owner even before the amendment comes, because under the agreement he is already saying that the Apartment Ownership Act is binding on the project. So he has to immediately surrender the entire common areas as per the Apartment Ownership Act by filing Form A. Then another thing is the carpet area definition, which is also to be amended. So this is the major changes that we have proposed, and there is every apartment owner has to become come under the Apartment Ownership Act after the project is registered and the common areas are submitted. So these amendments are something which has to be seriously taken up, and I hope the discussions that we are having here can also be incorporated after discussions. We had, I tell you, the major problem that we are facing is the competent authority in Apartment Ownership Act is the Secretary Housing Board. So, and RERA is under the local self-government. It's under Housing Board. So there is also a problem with the ministers because they belong to different political parties. And initially when RERA also came up, it had to be under the housing. But then due to political conciliations, finally LSGD ministry is looking after RERA, while everything happens with the amendments, appointments, everything happens with the housing department. So even we applied to this post to the Secretary Housing Board, Secretary Housing of the Government of Kerala. So this is where this happened. Recently we had a discussions with the Law Minister on this, and asked them to convene a meeting of the Secretary Kerala Housing and LSGD and the Law Department, so that this can be done immediately if the Apartment Ownership Act and also RERA is to be implemented as far as the agreement that is being done. Because once the agreement is executed under section 13(2), the government gets the entire amount, because this agreement specifies the total cost under carpet area. So if the builder is selling at 1,000 rupees, 8,000 square meter of carpet area, then the total cost is 80 lakhs. That is reflected in the agreement. So before collecting any amount above 10% of the project cost, the agreement is registered, it is recorded, and there was no need for in the budget to increase the apartment registration charges. The government is in fact going to get more if they implement section 32 registration. That is something also we had discussed about the earlier, but the registration of apartments under section 13(2) is not happening the way it should have happened. So during the discussion with the registrar, we had impressed upon them this particular aspect where the registration under section 32 is compulsory, and the government will get more revenue by reducing it to 5% if required in future. So these are the aspects that we have raised before the government, and we hope the Society of Construction Law also takes it up seriously with the government, and also I think there are some petitions coming up in the form of public interest litigations for implementation of these laws before the Honorable High Court. So all these will add up to the pressure on the government to get these laws amended in the interest of the allottees and also to the promoter. Thank you.
Thank you, Mr. Matthews. You have advocated for change of law. Perhaps all every one of us support, but it is for the government and for the society. For construction law may not be able to change the law, but existing law has to be administered, whether it is under the Kerala Apartment Ownership Act or even later Act of RERA. Now let us hear the builders' view. Builders may not have any big problem except for what is already done, if it is anything wrong. That, of course, Act will not govern. Anyway, let us have reviews from Sri Rian John, who is Managing Director of iLife Builder Thrissur, Governing Council and Legal Committee member of CREDAI. You can be brief. You can be brief.
Good morning. Rajendra sir, Chairman of the meeting, Mr. Johnson, Matthew sir, Commander D. Matthew, Advocate. At the outset, I would like to appreciate the initiative taken by the Society of Construction Law for organizing a meeting for discussion about Apartment Ownership Act. And also we are very grateful to the association for giving us an opportunity to present our views in this meeting. And Rajendra sir പറഞ്ഞ ഒരു point, I would like to quote the same thing. Ultimately, the interest of the purchaser is to be safeguarded. That is what we also believe in our heart. I also remember one, 2, 3, maybe 4 months back, Matthew sir and Kujan sir organized one meeting of RERA committee at Thrissur also. In the inaugural session, Kujan sir, the chairman, said, you builders should hear me for one thing, that this RERA registration is a promotion for your products. It is a fact. When I say that my product is registered under RERA, it is really a promotion. Because what happened after RERA, Matthew explained perfectly, the confidence of customers increased. They have got a confidence that the builder will complete the project and the builder will hand over the project in a proper way. In effect, the industry, RERA is an act which really helps for the industry. As a builder, I would say it is really a blessing for this industry. And the same way I think about Apartment Ownership Act also. Because we are facing a lot of issues regarding this present Charitable Society Act and other things. So we also really appreciate the initiative of this society taking initiative for this Apartment Ownership Act. I would like to share with you some of the views on the side of builders regarding this Apartment Ownership Act. See, Matthew said in Kerala, almost all apartment owners are registered under, apartment owners associations are registered under the Travancore Kochi Literal Scientific and Charitable Societies Act. You know that we have a lot of limitations for the charitable societies regarding, especially regarding this asset management. Apartment owners also find it very difficult to collect maintenance fees from members because any forced conditions are not imposed on owners for fee collection. As a charitable society, you cannot impose that much force for collecting that. I know that they will explain that in details. Next slide, please. These are all difficulties what we are facing right now. Of course, there is no clarity or uniformity in fixing maintenance fee. You know, some associations are collecting maintenance fee equally from 2-bedroom, 3-bedroom, 4-bedroom. Everything is equal. But for some other associations, there will be some difference between 2-bedroom and 3-bedroom. For some associations, they are collecting based on their carpet area or built area line. Different ways of collections. Fortunately, I think RERA insists for maintenance fee collection based on carpet area. But at present, there is no uniform method for collecting. So that makes a lot of issues in associations. And of course, there is no uniform method for calculating the undivided share of land when we transfer the land. That is also a problem. Then there are a lot of issues. You all know that there is newspaper issues, newspaper news every day regarding the pet policy in apartments. Bachelors, especially in Cochin and Trivandrum, we are all facing a lot of issues because this IT field is improving very much. Bachelors accommodation is a problem. Some associations are reluctant to allow bachelors accommodation living together. This is all our issues. There is no clarity since we don't have an apartment law, we don't have an apartment association. No, there is no clarity. Everywhere there are a lot of issues between association and members. I would like to share something about RERA also. Matthew said explained everything in detail. In Kerala, builders are transferring the entire land of the project as share to the clients so far. That may be in proportion to the built-up area of apartments. Basically, Mr. Commenter may be sharing their views. Basically, our clients are happy because we are transferring the total property and undivided share to the clients. After the completion and after handing over of a project, the builder has no right in that project. Perfect. Client is happy as I said, they have got an undivided share in the property also. But once there comes, as per RERA, common area definition is the entire land of the real estate project. And that total land area to be converted to be transferred to the association. Means the client, as a client, they are not getting any undivided share of interest. This is a point to be discussed in client forum also. Whether they should get undivided share in the property or they prefer to transfer this undivided share to the association. You please discuss. In my opinion, we have discussions with some associations. They said the present system is good, so that they are getting the undivided share. That area also to be discussed in detail and to take a decision while we form this apartment ownership. As per, sorry, last slide. See, in Telangana and Tamil Nadu, as per their apartment ownership act, undivided share can be transferred to clients based on their carpet area of apartments. That may be information for us also. Since, in Kerala, Apartment Ownership Act 1983, there is no clarity for this thing. Okay, next slide. There is a difference in carpet area also. As per carpet area, balconies are not considered in carpet area. So, what happens, if you transfer the undivided share also based on carpet area, based on carpet area, the one who is having balcony and the one who has paid money for the balcony will not get proportionate share of undivided land, while the party without having a balcony, there will be a matching difference will be there. So if you go for carpet area, that is also a problem. So we may suggest either plinth area or a built area, proportion may be better for sharing undivided share of land. Okay, next slide, please. See, now the Kerala Apartment Ownership Act 1983, there are some limitations which can be improved. Undivided interest in the common area to be worked out on the basis of value of apartment, not on the basis of plinth area. That is an area which we should discuss. As a builder, I can tell you, when we launch a project, we sell a product for 75 lakhs. Maybe at the time of completion, we may be selling the product for 80 lakhs. Maybe the finance cost is also there. But when you share the undivided share, you should, based on value, means same size of about 1,500 square feet apartment, one buyer bought it for 70 lakhs, one buyer bought it for 85 lakhs. Now, 85 lakhs by same area, they are getting more undivided share. That is not a logic. And this is applicable for residential apartments. Kerala Apartment Ownership Act is basically applicable for residential projects only. I think we should include the commercial project also in the purview of this Apartment Ownership Act. And the villa is also not included there. Next slide, please. You all know there is no registering authority, no separate provision for levy of stamp duty and registration fee, no proper instruction given by state government to sub-register, no separate registers kept by registering authority as mentioned in the Act. That is the only reason that this Apartment Ownership Act is not yet implemented. Next slide. There is an amendment proposal for Apartment Ownership Act in 2015. That is, I have shared with Mr. Johnson. I can share a copy of that also. There are some improvements in this amendment proposal, but that is also not adequate. All types of developments, commercial projects are not included in it. Joint and several ownership not circulated for public opinion. Next slide, please. And stamp duty registration fee only fixed. You had a very bad experience there. I know what is the experience of Advocate Johnson regarding the Registration Act is to be amended for this project. Next slide. Some of the suggestions for improvement. See, another area, I don't know whether it is important to share it with here. See, what happens with association? I know there are some association members are there. After formation of association, many common areas like fire, KICB, pollution, electricity, water, that all will be in the name of builder. After handing over, maybe after 10 years, after 20 years, this electricity bill may be in the name of builder. You know what happens? Association losing their power on these common facilities. That is also to be, if possible, that is also to be included in the apartment ownership. There should be a system to transfer easily these all common areas to the association. Very difficult. You know, water connection transfer is very difficult, impossible in some areas. There should be a clarity on maintenance connection fee. That is first part. There should be a system for transferring all common area facilities to the association immediately after forming the association. We always share with Matthew sir and Kurian sir, you know, RERA proposed to complete the project on time. Completion is not only concession. We should get the completion certificate, occupancy certificate, electricity connection, water connection. Everything should be in a limited time. What is our control over this certificate? Now, we have to take our genuine interest in getting these all documents, but there is no rule for that. You know, we are not able to include these government officers in the purview of this law. At least that is the same thing what happens for transferring this common areas to the association also. The next point is about the collection of maintenance fee. That is also, as I said, 2 by 3 by 4 by different collections, different methods, different associations, always issues. I suggest there should be a clarity in Apartment Ownership Act. RERA may be insisting for carpet area. Something should be there, uniform for everyone, so that there will be no issues in association. Next point, please. If required, you know, that we have a lot of association here so far. That is all registered under Charitable Societies Act. I don't know whether you may be better people to decide on this thing. If we form an Apartment Ownership Act, if required, there will be a provision to convert this societies to Apartment Ownership Act, if required. That may be better, I think, in future. If there is a scope for redevelopment, maybe that is what is happening in places like Mumbai. Redevelopment is happening. I don't know what will be the status of a society registered under Societies Act. Maybe if it is registered under Apartment Ownership Act, for the redevelopment that may be a little more better. And you know, even though some societies are not registered, not at all registered, the association leaders are not at all interested in registering this association, even in Charitable Societies Act. So I think it must be compulsory. Registration of an association must be compulsory. And the another area what I think, you know, in Kerala is such a small state where after transferring this undivided share of property to the members, mutation is there. Now, when you sell a property, after there is a mutation. It is happening in Trivandrum. After transferring transferring the undivided share, he can go to villages and he can get the mutation done there in Trivandrum. Maybe in Trivandrum, not in Cochin, not in Tiru. Different, in Kerala, different for different village offices. I prefer immediately after transfer of, I prefer in our CRED, I prefer immediately after transfer of this undivided share to our clients, the mutation should also happen. If apartment ownership act insists something like that, that is also will be very good. Next. Okay, that is all. One thing also I want to include, talking about independent apartments only. There are some cluster apartments there. That requires some federation, concept of federation is to be required in the Apartment Ownership Act. Then only, independent apartment is there, apartment owner association will be there, and there should be a federation of these all apartments, and there should be a federation for this association also. And redevelopment clause also should be very clear in Apartment Ownership Act. So that it will be easy. In some areas, I know in Mumbai, some areas where 99 members of the association decided to go for a redevelopment just because one member's interest, nothing is happening there. You know what happens for redevelopment? If there is 100 clients in an association, 99 clients agree for a redevelopment after 100 years, one person can make issues. So if there is a clarity for redevelopment in Apartment Ownership Act, that will be helpful for the benefit of the clients. As again, let me repeat the same thing. Ultimately, the interest of the clients to be safeguarded. The Apartment Ownership Act is to ensure some areas, some definitions to be required in Apartment Ownership Act. That is, there is no definition for project, promoter, reserve car park, sanction plan, sanction authority, site area, that all silly things. Once again, let me say that I really appreciate the initiative. Thank you very much. I hope that there will be any improvement for this.
Thank you, Mr. Acharya. Has become a moot question. My friend Ms. Matthews wanted a legislative change totally. Yes. Here, Mr. Cherian also wants total legislative change, including definitions. Mutation is available in Kochi also. I got mutated my apartment in Kochi city. But they don't know. The lack of knowledge, they should approach the proper persons. Okay. The Commander Dean Matthew, Secretary, Fifth Apartment Owners Association, is the vital point, vital individual. Victim. No, after all, you cannot be, we cannot be victim. Every one of us are owning one apartment or building. After all, we are all beneficiaries. I don't say victim, but if we don't move in the right direction, under your guidance, perhaps something wrong will happen. Please, you present your views.
Thanks. Senior Counsel Advocate Rajendran Nair, RERA Member Mr. Matthew, Mr. Cherian John, Advocate Johnson Gomes, distinguished audience. First of all, I thank the Society of Construction Law Kerala chapter for organizing this seminar, a good initiative, and give me a chance to share our experience and views in this forum for common good. From the discussions so far, it's very clear that an act that was passed and made into a legislation almost 40 years back has still not been made implementable. it's no surprise that nobody has wanted to use it, or there is no pressure from any of the concerned agencies to force the intended users to use it. Things are so far pretty clear. And I use the word victim, sir, because if this seminar was about rape prevention laws, then I represent a gang rape victim. The perpetrators are right from legislative to everyone in between up to judiciary, through either their indifference or maybe lack of interest in performing what they are expected to do for the common cause. Why this act is today thoroughly unimplementable? If you give me 5 minutes to narrate our story, it is easy to come and give a realistic touch to this conversation. Mostly such seminars and conversation end up being academic. We discuss about various laws, various paragraphs, various sections. I will speak as a layman who tried to use that act for our benefit. The only crime we did was we were the first community who insisted on registration under this act. 3 years back, actually, to be honest, we also didn't know about this act. This is an accident. Trithum, our community is just 6 years old. People started living there from 2016. And in our sales agreement, the builder with all good intentions said, we will help registering the association, owners association, and it will be registered under the Kerala Apartment Ownership Act of 1983. We said, fine, you know, like all of us, we signed the same agreement, 30 pages without reading anything. And people who owned maybe another apartment before, like me, I thought every time it is Society Act, no, by this Apartment Ownership Act, no one heard about it. We said, okay, let it go, we'll see. So we, the size of the complex is about 572 apartments. And almost 80% are sold today, about 20%, about 100% yet to be sold after 6 years of existence. So in somewhere in 2020, just 2 years, 2.5 years back, the builder said, okay, now we have about 300 plus apartments sold. Let's form the association, we'll help. We'll call a general body. The general body was called, it was a good response, and draft bylaw was prepared by the builder and circulated, and bylaw was discussed. The general body with the majority adopted the bylaw, and then elected the AIIMS management committee, secretary, president, everyone. Then the next step, registration. It was COVID time, and some of the government offices are not functioning or partially functioning. So our builder, in all honesty, they started the registration process by trying to file this declaration as stipulated in the Apartment Ownership Act. Then they came back to us saying that, sorry, we cannot, fulfill what we promised to us for registering your society under Apartment Ownership Act. It is too cumbersome. We together managed to register about 10 declarations. 10 declarations from 10 apartment owners. Builder came back to us and said that, sorry, we can't do anything more than that. It's too cumbersome. Plus COVID, and everyone used to blame on COVID for anything. And we don't have the infrastructure. We don't have the office staff to cover for everyone. So we are dropping the ball here. If you want, we can get you registered under Societies Act. Then we said no. It is mentioned, we signed up for getting registered under the Kerala Apartment Ownership Act, and now we discussed it sometime at some length. We also feel that this is the right act. This is an act specifically brought in for managing the condominium or apartment complex properties, let's go for it. Why tell a lie that we are a charitable society or a literary society? Why tell a lie? We are an apartment complex and this is an apartment ownership and owners association. Let's go and register under the, how difficult it is. Okay, then they said, oh, that's your baby now. If you want, we can help you registering under the Kerala Societies Act. Or otherwise, you look after yourself. Then we said, okay, thank you. So, Nori, we will take care of ourselves. So, this is a crucial point we made. We told them, thank you, no need. If you're going to register us under Societies Act, we don't need it. We want registration under Kerala Apartment Ownership Act. If you can do it, we'll do it ourselves. Then we started, we got in touch with Advocate Johnson. We started exploring how to do it. We went to the competent authority, Then we went to the High Court, praying High Court's direction, saying that please direct whoever it is to help us with the registration of the association. Finally, High Court issued an order. The government appointed the deputy collector, disaster management at the competent authority for Ernakulam district, and the competent authority under the deputy High Court gave us we call us a registration certificate. Somebody calls just a receipt of what you submitted, a file number saying that this has been received, and so it doesn't clearly still say you are registered as a society or registered as a apartment ownership association under the rules and regulations. And then according to the Act, there should be a separate structure, infrastructure in the sub-registrar's office, separate register to be kept for all these associations or societies registered under this Act. And competent authority is supposed to, we don't know still, who's the ultimate registration authority say that this apartment is registered. So what happened now today? Then in-house we have no issues. We are going ahead with our life as normal as possible. We have now I represent the third management committee. Okay, I was secretary in the last committee also. We have democratic elections. We form management committee. We collect maintenance fees. We take care of the property, we spend the money, account it, audit it, general body. But what happens is, there's a strong section of our own community challenging us. Who are you? Who gave you legitimacy? Just by deputy collector giving you a receipt doesn't make you a legitimate society, registered society. That number you give is a file number, it is not registration number. So even today, we have a fight there. That even when I try to tell something, there are people, including senior legal professionals, asking, who are you? We are not a registered society. Then I'll go back a few months prior. So we went to RERA, saying that please help us. The builder promised to register us under Kerala Apartment Ownership Association 1983. They said they went halfway, they dropped the ball, and then we had to go to the High Court and get an order to direct government to do that. But this builders failed in ordering his promise to help you to complete the registration process. Please direct the builder to do that. RERA heard our plea, got the builder. Couple of months back, we got the order from RERA judgment. I am not using this forum as criticizing or challenging the RERA order, because we formally, it's the next step, because we don't agree with or we disagree with RERA order, we have gone to the appellate authority to challenge it. So RERA order said, see, the builder is supposed to help you with formation of the association and registration. He tried. And at some point you said, no, we don't need your help. Then builder has done his duty and we can't find fault with the builder. But in the judgment, the authority didn't look at the context, why and how we ended up saying no to it. We ended up saying no only for builders. Second option is registering us under Society Act, which we said no, clear, accepted. But that doesn't absolve the builder from not honoring his original promise of registering under the Kerala Apartment Ownership Act. Then one of the members in the order went 3 steps further. That member addressed the legality of our association. He said, you are only 10 members because only 10 declarations has been filed. How can you claim that you are an association representing the majority? So at that point, the member ignored the fact that there is a bylaw adopted by a general body majority approval and democratic elections going on. Management committees and day-to-day businesses being conducted, properties being maintained, money collected, accounted, audited. So that came as a big shock to us. It just happened a couple of months back, saying that from in the RERA order itself, even I don't know whether it is ordered or not, RERA order questioned our legality. Then no wonder, what will happen back home. Everyone started the big, look, we have been telling you, you are illegitimate. Your registration is hollow. On top of that, look what RERA said now. RERA also said that your registration is hollow. Only 10 members in the association. How can you claim that you have the authority to collect the money from us? So there are people who are not paying the maintenance fees just because this grounds. Who are you to ask money from us? But they will enjoy the facility. That's a different thing. If something is not working, they come and complain. But there are people, a good number of people still not paying. So now, why it is so? It is, now we have gone through the law or struggle with it. We know that there are 2 major problems with the Act. One is the definition of the applicability of the law, the famous or infamous section. We say that the Act is applicable to a society where the sole owner or all the owners are signed the declaration, registered it. Just think of it. Now, most everyone has touched upon it. We have 572 apartments. Some are to be 20% still to be. But is it possible to gather all 572 people and get the declaration signed and give it for getting the registration process complete? The second thing is the chicken and egg situation. On the one side, the Act said that all the documents submitted, declaration, etc., has to be submitted officially by the Secretary and Management Committee. But how will you have Secretary and Management unless the association is formed? To form the association, you have all the declarations submitted there. So, which comes first? So, as a practitioner, not a practitioner, as someone who wants to use that Act, which is made for us, governing us, what actions needed from our point is, on the ground. Number 2, the Act has to be cleaned up. The inherent contribution has to be cleaned up. Section 2 has to be just one simple sentence. This Act is applicable when the owner, the sole owner, the builder, submits all the declarations for all the apartments. That's the only way how it can work. Because the moment the first apartment is sold, then it becomes uncontrollable situation. So before the first apartment is sold, it has to be made mandatory on the builder by this Act that the builder has to file the declaration for all the units with the competent authority and complete the registration process. Then when the units are sold, it can be just made a statement in that saying that your apartment has been registered with the competent authority under the provisions of Kerala Apartment Ownership Act 1983. Simple. Don't wait for all owners to assemble. It will never happen. It will never happen. Because practically we know that. Even forget about 572. Even getting 50 owners together willing to file this declaration is impossible. 50 people have different views. Why should I? Somebody will ask. So, to avoid all the complication, the amendment has to be made to Section 2 regarding applicability of the the law, simple one sentence. Sole owner, the builder is mandated to complete the registration process by submitting declaration for each and every unit with the authority. Simple, the matter is closed. Then, second point is unnecessary connection. It is not mentioned clearly in the Act, but like the RERA member did, it can be interpreted that your association membership is linked to your declaration submission. No need. The declaration submission, the Act clearly says just to make sure that inheritable ownership to your property, not your association membership. Association is it's a body to be formed to manage the property. So association membership should be very clear, linked to a general body majority passing a bylaw as a common guidelines for managing the property and the conduct of the members. Nothing to do with your registration of the declarations. So this is the second point where the Act has to be cleared, very clearly mentioned. The declaration of the submission of the declaration has no connection with associate membership. If you are an owner there, if you want to own a property, you are expected to be automatically a member of the association and subject to the bylaws adopted by the majority in the general body. So if we do get these two things clear, most of the problems related to this Apartment Ownership Act of 93 is solved. Then there will be minor corrections as when more people start adopting and practicing, that may come from practical experience. If these two changes are made, at least this law is doable. People can try using it. Now today what happens, like us, following us, any society or any apartment owners association who want to use this act, they are forced to go to the High Court. Everyone knows that they are following our footsteps. You people got the registration through a High Court intervention, so they are also going. So High Court will give you where whoever goes. Why should we have a system like that? There is an act passed by the legislature 40 years back. Why should every would-be user be forced to go to the High Court to get a directive? Let's judicially use its powers to direct the government or whoever is responsible to clean up the act and make it usable. Also, according to that, there should be a competent authority clearly defined. Regulatory infrastructure, statutory infrastructure like separate section in the sub-registrar office to track this. And most importantly, there should be, as part of the judiciary intervention, a clear stoppage or clear directive to the Registrar General or whoever is the executive body to stop from immediate effect registration of Apartment Owners Association under Societies Act. We know it is a lie. No Apartment Ownership Act is an ownership association is a charitable society, not literary or scientific society. Why we are forcing or allowing them to register under the Societies Act? So judiciary should clearly give a direction. No, from today, no more registration of apartment owned associations registering under Societies Act. With this is the only way to first get the act cleaned up. Secondly, give clear instruction from tomorrow onwards, no more registration of apartment owners association under Societies Act. Then maybe another 2, 3, 4, 5 years, we'll have things stabilized. People start using this. Otherwise, there is no end to it. People using some excuse or other, even today, our complex, the senior advocates telling that you don't understand law. This is not law. You should go and register under the Societies Act. And they are. So this is the only way to use clear instructions saying that nothing doing, this is the act. Use it. Otherwise, this drama will go on.
Okay.
Thank you. Thank you for listening, Mr. Sala.
Now, I think the organization suggests a short break and come back for further discussion so that we will be fresh. Now, all the three panelists have advocated for legislative change. Lawyers normally stand for judicial resolution of the dispute. Lawyers, as a lawyer, I would say, suppose the legislature refuses suppose the legislature refuses to do that, is our remedy in this MKD hall or on public street? I don't know. The only possibility is have a judicial resolution of the problem. We will discuss it after we come back after this short break. Please.
As Rajananda said, we have a tea break now, and after which we'll have an open floor for discussion.
എന്ന നിലയ്ക്ക് അപ്പാർട്ട്മെന്റിന്റെ ഓണർഷിപ്പും കിട്ടി. അത് പ്ലിന്ത് ഏരിയ ആണോ കാർപ്പറ്റ് ഏരിയ ആണോ എന്നുള്ളതൊന്നും വലിയ അത് ഡിഫൈൻ ചെയ്യണം, വേണ്ടതല്ല, വേണ്ടത് തന്നെയാണ്, അതൊന്നും വലിയൊരു പ്രശ്നമല്ല. പക്ഷേ അപ്പാർട്ട്മെന്റ് ഓണർ എന്നുള്ള നിലയ്ക്ക് ഈ അപ്പാർട്ട്മെന്റ് ഓണർഷിപ്പ് എനിക്കുണ്ട്. പക്ഷെ അത് അതിന്റെ ഫുൾ റേറ്റ് ഉണ്ടോ, അടുത്തുള്ള ഇതുണ്ടോ, ഇതൊക്കെ രീതിയിൽ വരുന്ന കാര്യമാണ്. ഷെയർ കിട്ടിയിട്ടുണ്ട്, 1.25 ഏക്കർ സ്ഥലമുണ്ട്, അതിന്റെ ഷെയർ ഞങ്ങൾക്ക് കിട്ടിയിട്ടുണ്ട്. അതൊന്നും ആരും ചെയ്യുന്നില്ല. പക്ഷെ ഇത് മാനേജ് ചെയ്യാൻ ആർക്കാണ് അധികാരം എന്നുള്ള ചോദ്യം ഈ ചാരിറ്റബിൾ ട്രസ്റ്റ് ആക്ട് അനുസരിച്ചുള്ള അസോസിയേഷൻ